HIPAA. It's everywhere, at the doctor's office and hospital, on the millions of forms you've been asked to sign, on insurance notices and websites. But what is it? Welcome. I am Martine Bruce, your medical bill whisperer, committed to bringing answers, insights, and solutions to patients like you. So today, let's go to the basics. What is it and who is concerned? And then I'll share tips to help you along. HIPAA, the Health Insurance Portability and Accountability Act, is a federal law that regulates the use and disclosure of individuals' health information. It gives patients like you the right to manage and control it. That health information is your demographic data, name, address, date of birth, social security number, any clinical detail relating to your health, whether verbally, electronically, or on paper, is confidential. Calls to your doctor, paper charts in an office, or medical information listed on any patient portal or insurance online account, but also your financial information, including insurance coverage, account balance, credit card information. All of that is private. The law tries to balance the right of individuals to their privacy with allowing a certain flow of information between eligible entities in order to provide high-quality medical care. And while you hold most of the power over your information, there are exceptions. Any entity with access to individuals' personal health information must abide, including insurance companies offering health, dental, vision, pharmacy policies, Medicare, Medicaid, Medicare Advantage plans, Medigap, supplemental insurance, and also long-term care insurance. Every healthcare provider out there, whether an individual or a facility, but also billing services and clearinghouses, those go-betweens for electronic claim transmissions. Third-party administrators and collection agencies must comply as well. And your business associates, the individuals or businesses you hire to manage and handle affairs and who have access to your personal health information. The accountant paying your medical bills, the patient advocate fighting your insurance, for example. And at last, you must abide if you hold information regarding another person's medical data. So telling your best friend about your Uncle Fred's cancer treatment without his consent is really violating HIPAA. What it means for you is that you hold the key as to who can see what records and why. A consent form may come in other names, but that is what opens the door to the flow of information HIPAA tries to keep private. Insurances have their own forms available online or on demand, as do hospitals. Offices use generic forms or may accept your own alternative. But with such power will come many signatures. When you request a copy of your own records for your own file or to share with another doctor or even to file an appeal. When you grant a personal representative access to your data, whether be an advocate, family member, or power of attorney. Whenever your insurance requests medical records to process claims or approve an authorization requests, or to allow your insurance to discuss claims, eligibility, or policy with your personal representatives. When a medical provider needs medical records from another office or hospitals, or an external entity needs a copy of your medical file for a legitimate reason, a new insurance you apply for, an attorney for a legal case, or the state if you file an appeal there. The law imposes an additional level of privacy and requires separate consent for mental health records and behavioral health records. Another level is also needed for sensitive information, genetic data, abuse and assaults, pregnancy, sexual health, HIV, and AIDS status are some of that sensitive information. And now, the law also gives your teens between age 12 and 18 an additional level of privacy. And yes, parents, that means power away from you. While you do have automatic access to your teens' medical files, you lose that control of sensitive data or mental health and behavioral health records once your offspring turns 12. So sorry. Your teen will need to sign a special consent allowing you to access this information and medical records. So best of luck to you. And your insurance can also lock you out of your teen's claims and other information unless they have a signed consent from your child. There is no need for a consent form per HIPAA in some circumstances. For public health purposes, your COVID status was reported to federal and state agencies without your consent. And your next of kin may receive clinical details if you are unconscious, incapacitated, but decisions must be taken. Hospital and insurance companies are allowed to compile lists of medical and demographic data for internal use. And a family member, advocate, or power of attorney can access medical or billing records for a deceased patient, even if no consent was ever filed. Medical providers must report suspected abuse, signs of assaults, risk of self-harm, and threat to others without your approval. Other mandated reporters include social workers, school officials, law enforcement officers, and more. And if ordered by a court or by subpoena, your medical records must be turned over without your approval. And last, I am not sure why it makes no sense in my book, but workers' comp cases are not covered under HIPAA. Yes, your employer and their attorney have direct access to your medical files. As for some helpful tips, sign a consent for those you want to share information with, especially before an upcoming medical intervention. And get a signed consent from those who want to share information with you. Otherwise, you will hear, "I can't give you that information," at the very worst of times. And don't forget to add any power of attorney paperwork if relevant. A signed consent is never set in stone. You can restrict access to your medical data from a family member, an abusive spouse, your parents if you're over 12. And you can also rescind a previous consent, someone no longer involved, an advocate who finished the job, your ex-spouse. And a last word of caution. Only grant access to your intimate information to those you really trust to keep it private, and promptly cancel any consent no longer needed or no longer in your best interest. And patients, remember, you have rights. Insurance companies have a duty to you, and providers must abide by certain rules. I so thank you for watching. Did you know your subscribes, likes, and comments are helping this channel grow? So do consider helping me to reach out to more patients just like you. Thank you.